Good evening, everyone. I am Lisa Gupta, the host of today's session. I, on behalf of the whole team of Just Corpus, welcome you all in today's session on the BNSS impacts and implications for modern criminal law by Just Corpus. Before we delve into today's discussion, let me provide a brief introduction of Just Corpus and the eminent guest speaker of the day. About Just Corpus. Just Corpus is a body of legal professionals who have come together to bring various aspects and chains of law under a single umbrella. Just Corpus, an edtech platform set up in 2020, has a wide reach of over 600,000 clicks per month on an average basis on our website. The inspiration was derived from the ever growing need for law students. Just Corpus has also incorporated an interdisciplinary journal and a multidisciplinary journal as its subsidiaries, named as the Just Corpus Law Journal and the International Journal of Law, Research, Education, and Social Sciences. Now, turning our attention to today's focal point, we are privileged to have Ms. Anshu Sharma, former judge, Gujarat Judicial Services, as our esteemed guest speaker. Ma'am has previously served as the judge in the Gujarat Judiciary. Her path has been marked by a spectrum of accomplishments, each contributing to her remarkable journey. Her career commenced as an additional civil judge and judicial magistrate, reflecting her unwavering dedication to the legal domain. Her academic trajectory is equally remarkable, holding a degree in electronics and communication engineering, followed by a triumphant LLB where she secured first rank and received the Best Alumni Award. Continuing her pursuit of knowledge, she earned a master's in business law, once again clinching first position for her exceptional performance. As an educator extraordinary, her passion for legal education led her to serve visiting faculty member at renowned institutions including AMSOM, Nirma University, Karnavati University, and numerous other esteemed colleges and universities. Fueled by a vision to transform legal education, she took a groundbreaking step by establishing Move Law Academy, a pioneering institute in India that redefines legal instruction through creative animation and progressive teaching techniques. The academy's impact has been nothing short of outstanding. Move Law Academy stands as one of the most distinguished institutes in Gujarat, with an impressive track record of over 50 successful selections in the judiciary, a resounding endorsement of her dedication and expertise in nurturing legal minds. She has shared her expertise through seminars at esteemed educational institutions, including Nirma University, Gujarat University, Ahmedabad University, Gujarat Law Society, United World School of Law, GLC Ahmedabad, and DPS Ahmedabad. Additionally, MAM has conducted seminars and training sessions for advocates and court staff at different courts in Gujarat, including Ahmedabad City Civil Court, Metropolitan Court Ahmedabad, Rajkot District Court, and for practicing advocates of Surendranagar District Court. Her journey is an inspiring testament to her commitment to the legal field and her profound impact on legal education. Without further ado, I would like to hand over the floor to ma'am for her insights on the topic.
Thank you, Lisa, for the wonderful introduction. And thank you, Just Corpus, for having me today. Okay, so without further ado, I'll start with the session. Okay. I hope everyone is able to see the screen. Okay. Let's start with the agenda for today's session. So today we will be discussing the major reforms which are present in the BNSS, which were not present there in the CRPC. Okay. So basically there are a lot of reforms which are there in the BNSS, which were not there in the CRPC. But today, because of paucity of time, we will be able to cover the 10 major reforms that are there in the BNSS. Today, I'll try my level best to make this presentation interesting by adding clips and some images. I hope that you people enjoy the session. Okay. The first takeaway for today. Okay. So the first takeaway for today is, how do you study big acts? Okay. So CRPC, as it was originally called, and now it is Bharatiya Nagarik Suraksha Sanhita. So all the big acts, how do you have to study that, which has a lot of sections? So the Guru Mantra to study big acts is to divide it into parts. Okay. So all of you who are preparing for judicial services or any other legal competitive examinations, I'm going to give you one trick. So any big act, you divide into parts. For example, okay, and the ones who are preparing for competitive examinations can take a note of this, okay, or take screenshot of this image. BNSS, when I teach BNSS, what I do is I generally divide it into 5 parts. Okay, so part 1 is introduction 1, part 2 is introduction 2, then there is investigation stage, then trial, and then post trial. Okay, so BNSS can be studied by dividing it into 5 parts, and these 5 parts can then be individually studied. Okay, so this you can do with BNS, then you can do with BSA, and henceforth. Okay. Now let's start with today's topic. Why was BNSS introduced? We need to understand this. Okay, the first important thing is any act. Okay, in any act, section 1 is short title, extent, and commencement, right? So short title means the name of the act. Why am I discussing this? Because for all judicial services examinations which are to be held this year, or for that matter, any competitive examination where law is one of the subjects, this year there is a possibility that they might ask you the name of the act. Okay, and they might give you very confusing options. Okay, so you have to be very particular with the name of the act. The name of the act is Bharatiya Nagarik Suraksha Sanhita. Okay, so they can give you options like what is suppose if they ask you what is the full form of BNSS, then they might give you confusing options like if it is Bharatiya Nagarik Suraksha Sanhita or Bharatiya Nagarik Suraksha Samiti, etc. So they might give you confusing options. So the name of the act is very important. Second, the enforcement date. The enforcement date of BNSS is again very important, which is 1st July 2024. Okay. Now, why BNSS was introduced? So with India modernizing, with the criminal justice system of India modernizing, there was a need to bring change in the laws which were there, which are prevalent since the time of Britishers. So the new acts are now coupled with the fusion of technology. Okay, and I'm going to show you some clips also. So which again, with the advancement of technology, there was a requirement that the new acts or the present law of the country had to be coupled with provisions which are having a fusion of technology. For example, the first important aspect that we would be dealing with today is online registration of FIR. Now, as we all know, online registration of FIR was already there, right? But there was no statutory provision. So with BNSS, we have statutory provision of online registration of FIR. The same goes with zero FIR. Now, what is zero FIR? I'll discuss this. Okay. Zero FIR. See, what is FIR? FIR is first information report. Okay, first information report with respect to any crime. All FIRs that are registered in police stations having jurisdiction, they are generally numbered. Okay. So, for example, 234/2024 and things like that. So, all FIRs have generally bear some number, and they are registered in police stations having jurisdiction to investigate these the crimes pertaining to these FIR. So I'll give you one example. In the famous Gurgaon MNC rape case, one rape had taken place in Sushant Lok area. Now, for all the people who live in Delhi or in nearby places of Delhi, they might be knowing that Sushant Lok is in Gurgaon, which is in Haryana. And then this the female victim of rape, she tried to lodge a complaint with the RK Puram police station, which is in Delhi. So Gurgaon, which is in Haryana, has a different territorial jurisdiction than in Delhi. So here, the RK Puram police station had shown hiccup of registering this FIR, right? So now Supreme Court had laid down important guidelines in this case, and they had said that any police station, even though if it does not have territorial jurisdiction, can register your FIR. It's just that they are not going to number that FIR. So since the number is not there, therefore it is called zero FIR. Okay. So those zero FIRs were registered before BNSS also, but there was no statutory provision. But with the new BNSS being implemented, zero FIR is there as a statutory provision. Okay, so this is the first major reform which is there in BNSS, which was not there in the CRPC, that zero FIRs are now statutorily present in the new act. Okay. Next, the next major change that we have seen with the BNSS is the hierarchy of courts. Okay. When I talk about hierarchy of courts at the third tier of court systems in India, we had courts of magistrates, and these courts of magistrates had were divided into two parts. One was for metropolitan areas, there used to be metropolitan magistrates, whereas for non-metropolitan areas, there used to be judicial magistrate first class. So basically, both the magistrates were of equal cadre, but it's just that there was a difference in the place of sitting. So any magistrate who is sitting in a non-metropolitan area was called judicial magistrate first class, whereas any magistrate sitting in a metropolitan area was called metropolitan magistrate. With the new BNSS, it has removed the classification of metropolitan areas and metropolitan magistrates. So from 1st July 2024, metropolitan magistrates will not be able to take new cases, which means that the metropolitan magistrate courts have been abolished. So there will only be courts of judicial magistrate first class, and no courts of metropolitan magistrates will exist for the cases which are to be tried after July 1, 2024. Okay, so this is the second major reform which is there in BNSS. So the first that we discussed was of zero FIR. The second is hierarchy of courts. Metropolitan magistrate courts have been abolished. Okay, now coming to the third reform, use of handcuffs. Okay, handcuffs, leg chains. So basically, our Supreme Court has time and again iterated in many cases. For example, in DK Basu versus State of West Bengal, in Prem Shankar Shukla versus Delhi administration, the Supreme Court had denounced the act of handcuffing. They had denounced the act of putting leg chains. It brings a lot of social stigma on the accused. And then Supreme Court has time and again iterated that until and unless there is no other way of ensuring the custody of accused, you should not handcuff a person. So basically, if I were to summarize it, I can say that handcuffs should have been the last resort as per Supreme Court guidelines. But the new BNSS, that is again, acha, time and again, I will be using the full name of the act so that by the end of the lecture, you are well versed with the name. Bharatiya Nagarik Suraksha Sanhita permits the use of handcuffs in various cases. I'll just show you the section. So according to section 43, clause 3 of the new act, it says the police may, okay. It is important to note the words may and shall, okay, they are very important in all provisions. So the police officer may, it shows that it is a discretionary provision. It is not a mandatory or an obligatory provision. It says the police officer may, keeping in view the nature and gravity of the offense, use handcuff. In which all offenses? In cases of habitual or repeated offenders, or people who have escaped from custody, or who have committed offenses of organized crime, terrorist acts, drug-related crimes, or illegal possession of arms and ammunitions, murder, rape, acid attack, counterfeiting of coins and currency notes, human trafficking, sexual offenses against children, or offenses against the state. So, in all these offenses, the provision of 43 clause 3 says that the police officer are now being entrusted with a discretionary provision of using handcuffs, okay, which earlier was not there. So this is the third major reform that BNSS has introduced. Okay. The fourth major reform that BNSS has introduced is the forensic investigation that has been incorporated in the BNSS. Okay. Now I'll show you a clip. This clip has been taken from Netflix and it is purely for academic purpose. In this clip, we are going to see how forensic investigation is important when it comes to investigations, how details in an how forensic details are relevant during investigation in crimes. Okay, so I'll show you the clip and then I'll come to the provision.
क्रिमिनल की पूरी हिस्ट्री सिर्फ एक धागे से निकल सकती है क्या? आपके लिए ये सिर्फ एक मामूली धागा या मिट्टी हो सकती है, लेकिन हमारे लिए ये किताब है, किताब अपराधी की पूरी लाइफ हिस्ट्री की। गौर से देखेंगे ना, पूरी कहानी दिख जाएगी। एविडेंस इकट्ठा करने में फर्स्ट रिस्पॉन्डर की अहम भूमिका होती है। ये उनकी रिस्पॉन्सिबिलिटी है कि क्राइम सीन इंटैक्ट रहे और अनटेम्पर्ड रहे, ताकि फॉरेंसिक साइंस लैब एविडेंस इकट्ठा कर सके। ये एविडेंस कोर्ट में पेश करने के लिए एक चेन ऑफ कस्टडी का होना जरूरी है। मामूली चीजें जैसे रेफरेंस नंबर, एफआईआर, तारीख, टाइम, आइटम डिस्क्रिप्शन और कलेक्टिंग ऑफिसर की आइडेंटिटी भी बहुत इंपॉर्टेंट है। एक केस को बिल्ड करने के लिए फॉरेंसिक का रोल बड़ा क्रिटिकल है। अगर एक छोटी सी भी गलती होती है एविडेंस इकट्ठा करने में, तो कोर्ट में आपका पूरा केस इनवैलिड हो सकता है।
Okay. So, forensic investigations are very important because detailed investigations can be done by using the forensic science. So, according to section 176 clause 3, the BNSS mandates forensic investigations for offenses punishable with at least 7 years of imprisonment. This is a very important reform which has been introduced in the new act. Okay, so the new act says that all the offenses having punishment of at least 7 years of imprisonment or more, there the team of forensic experts need to visit the crime scene, collect the forensic evidence, and record the process on mobile phones or any other electronic devices. Okay, so again, it is a mandatory provision wherein for heinous crimes, the BNSS says that forensic investigation is required for detailed investigation so that the minutest of evidences should not be left out. Okay. And as the forensic teams or the forensic science experts are more well equipped with the recent advancement of technologies, their expertise can be utilized in investigation procedures. Okay. Next. So the fifth major change that is there in the new act is electronic mode of investigation. Okay. I'll just read out the provision first. In BNSS, section 105 states that when the police conducts a search or seize property under Chapter 7 or Section 185, police must use audio-visual electronic means, preferably mobile phones, to record the entire process. Okay, just imagine a police officer coming to your place and you do not know. Okay, suppose if a police officer is conducting a search or a seizure and if they are recording the entire process, imagine how easy it becomes for them to investigate the case, to record the demeanor of the witnesses. So this thing was already prevalent in countries outside India. Okay, but now with the incorporation of the new act, this provision has also been incorporated in our system. Okay, I will show you another clip where there was an Indian couple who were living in a foreign country. This man allegedly kills his wife, and it is alleged that he has killed his wife, and the missing report was registered with the police station there. So the police authorities, they visit their home, they visit the home of this Indian couple, and they were having body cameras. So these body cameras, they captured the demeanor of the accused in this case, and by the fumbling of words, by how he is behaving in front of the police, how he's changing the statements, you would understand how important these mobile phones, body cameras are there during investigation. I'll just show you the clip.
Hello, sir. How are you? I'm off the BNSS part, please. We're looking for Miss Mamta Kafle.
Yeah, she like on Tuesday, Wednesday, she left and then she said she gonna go either New York or Texas, and then she left she had the phone and then she destroyed that phone and then she left.
So she destroyed the phone and she left. She said she was going to New York.
Yeah, our sister, one of our sister.
Okay. Do you have any other contact information?
Yeah, I like she have a different 3 phones. I do have like 2 phone numbers. One phone number somebody other receiving, one another for contact number for the New York. I do have.
Okay, can you show me that? Can you show me that numbers?
Show me those phone numbers from you.
Yeah, we just want to see if she's okay because we have it in work.
Okay, did you see how this man was changing his statements time and again? He was fumbling with the words. See how important it is to record these investigations, because ultimately, see, it not only helps the investigating authorities, but it also helps the court, right? So these things which were already there in the foreign countries have now been have also been incorporated in the Indian system now. I will show you how it has been incorporated. See, here the police, they have also started using body cameras. Okay, so these body cameras, you might have seen while you cross the red signal, you might have seen that the police officers, they are using body cameras these days in order to record how they behave with them, how you behave with them, and how the general public behaves with them. So that ways, now again, the investigations, the trial procedures become simpler with the use of these body cameras or phones, and of course with the use of the advancement in technology. Okay, moving ahead, the sixth major reform that is there in the BNSS is, see, in the old CRPC, a magistrate was empowered to order any person to provide specimen signature on handwriting. Okay, so I will give you an example. Suppose if your handwriting is in question in a case, okay, you claim that this is not my handwriting or this is not my signatures are being forged. So what remedy was there with the magistrate? The magistrate could have asked for your specimen signature, right? Now, the scope of this section has been widened. Okay, so now apart from asking for specimen signatures or handwritings, the magistrate can also ask for your finger impressions and voice samples. Now, as I just mentioned, that voice recordings, footages, and all with advancement of technologies, we have recordings of we have recordings and we have voice chats. So here, the magistrate can now order for, the magistrate can now ask for a specimen voice sample also. So this has already taken place in the Sheena Bora murder case. So in Sheena Bora murder case, Indrani Mukherjee, who is the alleged accused and mother of the deceased, okay, so some voice chats were taken into custody. I mean, the mobile phones were taken into custody, and some voice chats were recovered from those mobile phones. So the question was whether in those voice chats, the voice was of Indrani Mukherjee or not. So for this, the court had asked for voice samples of Indrani Mukherjee. So now the new BNSS has expanded the scope of this section, and it says the magistrate, apart from asking for specimen signatures and handwriting, can also ask for finger impressions and voice samples. Okay. Next. Okay, this is the most technical part of this entire presentation. Otherwise, I think the rest of the things are very easy and self-explanatory. But this is the most technical part for the ones who are not aware of police custody and judicial custody. But I would try my level best to simplify this and explain it to you. Okay. The major change that has taken place in section 187, which was earlier in section 167 of the CRPC. So this was earlier 167 CRPC. Presently, it is 187 BNSS. The BNSS allows up to 15 days of police custody, which can be authorized in parts during the initial 40 or 60 days of the 60 or 90 days period of judicial custody. So this is the major change. Okay. I have been told that in this session, we have a lot of law college students also. So I am presuming that these students might not be aware of the types of custodies. So before elaborating this section, I would take a minute to explain the two types of custodies that this section talks about. So custody is of two types. First is police custody, and the second is otherwise than in custody of police, which we generally term as judicial custody. So police custody means when you are in police station, when you are detained in a police station, whereas judicial custody is when you are in jail. Okay, so these are the sample images of police stations and jails. Okay, now the maximum period for which a person can be detained in a police custody is 15 days. Okay, and in no case the police custody can exceed 15 days number. Is that okay? Now the second is judicial custody. Now the judicial custody varies from 60 to 90 days depending on the nature of crime. So if a person has committed an offense which is punishable up to 10 years of imprisonment, the maximum judicial custody can be of 60 days. Okay. Whereas if a person has committed an offense which is punishable for more than 10 years of imprisonment or life imprisonment or death penalty, his maximum judicial custody can extend up to 90 days. So to summarize it, police custody can be for a maximum period of 15 days, whereas judicial custody can be for either 60 days for offenses less than 10 years of imprisonment and 90 days for offenses which are which are punishable up to imprisonment of imprisonment having more than 10 years, life imprisonment and death. Okay. Now coming to the change. This police custody of 15 days can now be granted in parts. Okay, so generally, initially in the CRPC, this 15 days police custody could be given in the first initial 15 days. Okay, but now they have changed this provision, and as per the new provision, this 15 days custody can be given, 15 days police custody can be given in the initial 40 days of the 60 days period for offenses having imprisonment, having punishment of imprisonment of less than 10 years, whereas this 15 days police custody can be given in parts for 60 days for offenses in which judicial custody of 90 days can be granted. Okay, so this is the major change that has taken place as per section 187 for the ones who are who have not studied either CRPC or BNSS. So this might be a bit technical for all of you, but for the rest of the people, you have to just understand that this police custody of 15 days can be spread in parts, and can be spread in what kind of parts? 40 days for the offenses where JC is 60, JC means judicial custody and PC is police custody. So where in cases where JC is of 60 days. So police custody can be given in parts. Police custody of 15 days can be given in parts for the initial 40 days, whereas where JC is of 90 days, the police custody of 15 days can be given in parts in the initial 60 days. Okay, so this is one major reform that has taken place in BNSS and which was not there in the CRPC. Okay. The eighth major change that has taken place in the BNSS is that it has been made contemporary. So you must have noticed that in all the important provisions, the addition of word audio, video, electronic means is there. So in all the relevant provisions and all the important provisions, the word audio, video, electronic means is inserted. Okay. The ninth major change that has the ninth major reform that has been incorporated in BNSS, which was not there in the CRPC, is detention of under trials. Okay. As per the provisions of CRPC, if the accused who has spent half of the maximum period of imprisonment in detention, he was to be released on a personal bond. But there was an exception to this rule. There was an exception that this provision was not applicable to the persons who have committed the offenses punishable by death, by the penalty of death. Okay. Okay. First of all, who are under trial prisoners? Under trial prisoners are the ones. Okay, somebody who is arrested and the trial is going on, and if a person has not been convicted by court of law, and if he is in imprisonment, he's considered to be an under trial prisoner. Now, there is a limitation that these under trial prisoners cannot be kept in jail for a very long time. So for how much time can they be kept in jail? So it is generally up to half of the maximum period of imprisonment in detention. Okay, I'll give you an example. Suppose if Mr. X has committed a crime, and for this crime, the maximum imprisonment is 10 years. And if this man has already spent 5 years in jail and the trial has not concluded, so he again gets, he can get a bail under this provision until and unless, but there was an exception, until and unless the offense for which he's charged should not be punishable by death. But this section, again, in the new BNSS, they have widened the scope and they have increased the exceptions. So initially the people who had committed the offenses punishable by death penalty were the only ones who were exempted from this provision. But now this provision will also not apply to offenses punishable by life imprisonment and persons against whom proceedings are pending in more than one offense. So this was again one major reform which was not there in the BNSS and which was not there in the CRPC and is now there in the BNSS. Okay. Next is timelines for procedures. So this is the last important reform which was not there in the CRPC and which has been now introduced in the new BNSS. So timelines for procedures have been incorporated. So the first one is it requires medical practitioners who examine rape victims to submit their reports to the investigating officer within 7 days. Okay, so in cases of rape victims, these are very sensitive cases. So basically, timelines, by providing timelines, you in turn not only expedite the whole process of investigation, but also considering the sensitivity of the case, it becomes important to provide a certain timeline in these cases. So in cases of rape, according to section 184, the medical practitioners who examine rape victims need to submit their report within 7 days to the investigating officer. That's the first change. That is the first timeline that has been provided. Now, the second timeline is the judgment needs to be given within 30 days of completion of arguments. Okay, so once the arguments have been completed, so within 30 days of completion of these arguments, the judgment has to be delivered, and which is extendable up to 45 days. But again, this period has also been made time bound. So the third change is informing the victim of progress of investigation within 90 days. So according to section 193 BNSS, the victim has to be informed about the process of investigation. And the last one is according to section 251 BNSS, framing of charges by session courts is to be done within 60 days from the first hearing on such charges. Okay, so once the session court hears completes the hearing on the charges, so charges have to be framed within 60 days from the first hearing of these charges. Okay, so these were the 10 major reforms that were initially not there in the CRPC, but have now been inculcated in the BNSS. Okay, just a quick review for all of you. I'll just repeat these 10 changes so that we can have a quick revision. Okay, let's start. So the first important part that we had, that we discussed today was how to study or how to go through big acts. So basically divide them into parts, and these, if you divided them into parts or into modules, it will become very easy for you to understand these topics and these subjects. Okay. Second was why BNSS was introduced. So it was introduced to couple the fusion of technology with the law. Okay. Next, we understood what is zero FIR. So zero FIR, the word zero itself shows that the FIR, these FIRs are not numbered. And why they are not numbered? Because these FIRs are not registered by police stations having jurisdiction. So a police station which does not have a jurisdiction need not number the FIR, but should record the FIR and then transfer it to the police station having jurisdiction so that they can have a numbered FIR there. So that in order to prevent unnecessary delays. Okay, so and in order to protect the interest of victims, it was important to incorporate the provision of zero FIR, which was already there by way of precedents, but now in the new BNSS, this is there as a statutory provision. Next, we discussed was hierarchy of courts. Hierarchy of courts, we discussed that the courts of metropolitan magistrates have been abolished, and now we just have courts of judicial magistrate first class. The third one that we discussed today was using of handcuffs. So the BNSS now permits the use of handcuffs in all these cases, and it is a discretionary provision. So the police officers may use handcuffs in the listed offenses which are given there under section 43 clause 3 in the BNSS. Then we discussed forensic investigation. In forensic investigation, all offenses which are punishable with at least 7 years of imprisonment, the BNSS mandates forensic investigations in these offenses. So it is mandatory to carry forensic investigations in such cases which are of heinous crimes, and forensic experts will visit the crime scene, collect the evidence, and not only assist the police, but also assist the court. Next is electronic mode of investigation. So the fifth reform that we discussed today was section 105. So the police may conduct a search should conduct a search or seizure of property and should use audio, video, electronic means, preferably mobile phones, to record the entire process. We saw a clip, and then we also saw how Indian police has also started recording all these processes, which are again very essential for not only investigation, but also to assist the court. Next, we studied the sixth major change, which was the magistrates can, apart from having specimen signatures or handwriting, can also ask for specimen voice samples and finger impressions. So we also discussed the Sheena Bora murder case, wherein Indrani Mukherjee was asked for giving her voice sample test, and she agreed to this. Next, police custody. In police custody, we learned that BNSS allows up to 15 days of police custody, which can be authorized in parts during the initial 40 days or 60 days of the 60 or 90 days period of judicial custody. So when the judicial custody of 60 days, the police custody can be granted in parts in the first 40 days. Where the judicial custody is of 90 days, the police custody can be granted in parts in the first 60 days. Next, eighth major change, the BNSS has been made contemporary by addition of the word audio, video, electronic means in all provisions. Detention of undertrials. Undertrials, we discussed, are the people who are still facing trial and the trial has not been completed. So what is the maximum period to which they can be detained? So generally it is half of the maximum period of imprisonment, but there are 3 exceptions to it. Initially in the CRPC, there was only 1 exception, but now 2 more exceptions have been added in this provision. So initially it was only applicable, the exception was only for offenses punishable by death, but now according to this provision, in the new BNSS, it will also not apply to offenses punishable by life imprisonment and persons against whom proceedings are pending in more than 1 offenses. And then we discussed the various timelines for procedures. As we all know, our courts, unfortunately, they do not carry a good name because of the inordinate delays in conducting trials. So it was very important for us to have some timelines for procedures, and the new act, which is Bharatiya Nagarik Suraksha Sanhita, the new act has provided with timelines for certain procedures to expedite these trials. So these were the 10 major changes that we discussed today. I hope you people understood the provisions that I wanted to explain, and may you have a joyful and enriching learning experience ahead.
Definitely, ma'am. Thank you for such an enriching experience and sharing your valuable and informative insights. If we have the time, may I proceed with the questions or the vote of thanks?
No, please.
Questions? All
Yes,
right, all right. The first question, how will BNSS impact the fundamental rights of citizens in cases of arrest or detention?
Oh. So in cases of arrest and detention, so basically it's a fundamental right under Article 22. Okay, so Article 22 says that against arbitrary arrest and detention, it is a fundamental right that we need to be protected. So now similar provisions are already there in BNSS, which talks exhaustively about how arrests are to be made, what are the guidelines in various cases like DK Basu versus State of West Bengal, Joginder Kumar versus State of UP, Neelabati Behra versus State of Odisha. So there have been many cases, and after which a lot of changes were made in the CRPC also, and in the new act as well. There are a lot of provisions which lay down the guidelines that have been issued to the police authorities while making arrests. Okay, so anyways, all the our fundamental right under Article 22 is preserved by the chapter arrest and detention in BNSS, which is already there and exhaustive.
All right, ma'am. Thank you. Moving on, what challenges might arise in implementing the BNSS in India?
Okay, there are a lot of challenges in implementing BNSS. Okay, for starters, it is very difficult to memorize, to unlearn what we have been practicing since years. Okay, so I will give you one small example. A friend of mine, she was mentioning that she had this case of 107. So 107, she initially thought that abatement section, she initially thought that this was an abatement section. Then she realized that it is the new BNS which talks about attempt to murder. Okay, so again, to unlearn what we have been studying and what we have studied, and again the shuffling of section numbers. Now 482 is no longer quashing and etc. So so it is again, it is very difficult, and especially okay. And the second, I think the what I have experienced is lot of senior advocates, lot of judges who are again who are very senior to us. They also face a lot of problems while trying all the technology related cases. Okay, so because they are not very well versed with technology, so this is one another hiccup that they are facing. But apart from that, yes, the new laws, I think one major issue that is there with the implementation of new laws is unlearning the sections and then memorizing the new ones. See, for a person who has never studied CRPC, I think it is not that difficult. But for the ones who studied CRPC, IPC evidence thoroughly, now I think it is a very big challenge to unlearn everything and then to memorize all the new sections.
Definitely, ma'am. Moreover, there may also be infrastructural challenges like the procurement of body cams and such for police officers.
Yes, yes, certainly, certainly. Acha, not only body cameras, I'll also tell you, I tell you something very important when we talk about forensic investigations. So now, since forensic investigation has become mandatory in offenses which are punishable up to 7 years of imprisonment, trust me, lot of villages, there are no forensic science experts in in a range of 200-300 kilometers. So there are a lot of remote areas where you cannot find forensic science experts. So again, I know that it's going to take a lot of time, but at the same time, uh, with advancement of technology, I feel that it is necessary to incorporate. See, I guess years back, we were not very, at least I was not very happy with using GPay. Okay. But presently, I think I have started using GPay every now and then. For every small transaction, even 10 rupees, I'll use GPay. Okay. So I'm sure that things will change here as well. But again, with body cameras and all, yes, I feel that it is a very good change. And bringing forensic science experts is even better.
Brilliant, ma'am. Moving on with the next question. Some experts argue that BNSS could centralize too much power in law enforcement. How does this law mitigate these concerns?
Okay, see, I do not agree to this. Okay, I do not agree to this general notion. See, and I tell you from where it has arisen. I feel that when you give lot of power to police, okay, so it is generally presumed that law enforcement agencies are being given a lot of arbitrary power, and then it will again lead to misuse of powers. But I feel that in the new acts there has been a balance of power, and I do not feel that there is an extra burdening on one wing and lessening on the other. I feel that there is a balance of power in all the wings.
All right. Fourth question. How do you see this change in the new criminal laws, and what do you think about the burden for the advocates?
Again, the same
You
thing.
have answered.
I think, but it is not only a burden on the advocates, but on the whole judicial system. It is a burden. Again, the aspect of unlearning, learning new things, and time and again. Okay, I have this. You can also keep it, huh? I mean, all of you, all the new advocates, you can keep this. I got to know it from. I got this application from somewhere. So I have this application in my phone wherein you enter the section number of old CRPC and then you get the new provision. Okay. So I think all these aspects, learning the new provisions, learning the new section numbers. So this is a big challenge. And again, and another challenge is all the pending cases that are already there before 1st July 2024. So they are to be run under CRPC, evidence,
Yes.
and IPC. And presently now, we after 1st July 2024, it is all new acts. So these advocates who are hanging in the middle, they need to be aware of both the old laws and the new laws. And I think that is one of the reasons why I have seen that in many competitive examinations, the testing authorities are asking for both the subjects. They would also ask you IPC questions, and they would also give you a corresponding BNS sections. So they want you to be well equipped with both the laws, because again, see, I'm sure that the old crimes which have already taken place, or the civil disputes which are lying in the courts for the past 2 years or 3 years, they are to be run under the old laws, and the new ones are to be run by the new ones. So again, I feel that it is a very big challenge for the advocates to have a balance of both old and new laws.
Mm, Moving on with my final question. How to implement technology which should complement BNSS?
Okay. See, technology which should complement BNSS, they are already doing it beautifully. So one is the usage of body cameras that they're already doing, as I just showed in one image also. Then uh, I think I was just I had a very beautiful opportunity of visiting forensic science laboratory here, and I think they're doing a beautiful job. I just saw the kinds of machines that these people are using these days, and I think it is wonderful. So I feel that all for cyber crimes, I'll give you one example. So for cyber crimes, for artificial intelligence, okay. So all the forensic science teams that at least I have had a chance of having to meet. So they are presently working parallelly with the emerging technologies, and with all the centers that I have visited in the past few years, I think they're doing a wonderful job.
Your perspective is very inspiring, ma'am, and it's really thrilling to have such new perspective and optimism. If I may have your permission, can I proceed with the vote of thanks?
Oh, yes, please. And thank you so much for having me.
The pleasure is ours, ma'am. In closing, we extend our heartfelt gratitude to Anshu, ma'am, for accepting our invitation and delivering such an informative session. We trust that the audience found it both interesting and knowledgeable. Thank you once again, ma'am, and we eagerly anticipate the opportunity to host you again.